conversation will be on John Mahamad's campaign tour of the northern region, but I'm chipping these two brief topics in because of the role you play. Now, having been an experienced member of parliament, one of the leaders at the time you were serving, and following the legal arguments, if you see the reaction by the Speaker of Parliament to the Chief Justice, to be specific, or Supreme Court as an institution, how do you see it briefly, so that I can take a brief comment and then we'll move on?
Well, it's just part of the legal processes. I mean, rule of law means you should abide to substantive law as to procedural law. Now, where law provides that something must be done and also provides how it should be done, you not only have a duty to do what is said to, to recommend to have been done or to be done, you have to follow the procedure laid out by the law for that particular thing to be done. Now, so what Bagbin, Speaker Bagbin has reacted to is the mode of service of the writ of sermons, invoking the original jurisdiction of the Supreme Court for an interpretation of Article 97(1)(g). That writ was left with the legal department of Parliament. That service is inconsistent with the procedure provided in Article 117. So, in the nutshell, what Bagbin is saying is that your service on the Speaker conflicts, breaches Article 117 and the practice direction issued by Cynthia Pamela and others.
The Supreme Court has become a subject of interest because of the controversy around some of the decisions or the rulings they make. Is this suggesting that they were rushing, or they themselves do not understand the laws that they are supposed to be helping us to appreciate?
Well, the Supreme Court has been very busy for various funny reasons these days. You recall that when Speaker Bagbin gave an interpretation to Article 97(1)(g) and (h), consistent with the previous interpretation placed on it by Michael Kwe, a member of the MPP, and particularly the majority leader, went to court to invoke the original jurisdiction. While the Speaker was still to decide, the Supreme Court did not find it necessary, or the applicant did not find it necessary to couple the application or the invocation of the jurisdiction of the court with a temporary measure, which we call interlocutory injunction. Now, they waited until he gave his own interpretation, his understanding of the law, and what that requires of him to do of the 4 rogue MPs, and then they rushed to court. And that's where the story, the funny behavior of the Supreme Court begins. Now, the application was an ex parte application, that is without notice to the other party. So you do it legally, in the ordinary parlance, at the blind side of the other party. The rule, or the 25 of the court proceedings, court rules, says that ex parte injunction can be given for only 10 days. Precisely because you want to restrain, maybe there's something that is happening that you want to restrain. But it is always important that you give the other party opportunity to come defend the matter. The Supreme Court did not give them 10 days. It tied the stay of execution with the final delivery of judgment on invoking their jurisdiction. That is, the stay of execution is almost in perpetuity, tied to the lifespan of the writ. 2, they said that the one reason they gave for doing that was that government business was going to be affected. But I know the Supreme Court is a creature of the Constitution. It has no speculative jurisdiction. Okay, that is one of the checks on the Supreme Court. They can't speculate what will happen. They only have to deal with facts. And so you will wonder where they got that speculative jurisdiction to rule that they were staying execution because government business will be affected. 3, they said they hadn't given the other party notice. Man, you have started by saying that the ex parte application was without notice. So if you were considering an ex parte application without notice, why? How can you approve it and reprove it? You understand? That was the first thing. The second thing is that I think that because they were in a rush, they failed to read Article 97. If you read Article 97 carefully, you will realize that where the drafters of the Constitution intended that the rules of natural justice must apply, they provided it. So when you read Article 97 1C, it says that where a member of parliament absents him or herself from parliament for 15 sitting days without the written permission of the speaker and without a reasonable explanation to the committee on privileges, that seat must be declared vacant. Those preconditions, in particular the second precondition, impose into the provision the requirements of natural justice.
Well, I believe that if I give you more time, you go on and on and on. But many of you have been listening to Inus Hussein, and I believe that you appreciate his interpretation of the law from his understanding of the constitutional law as they want to place this controversy. Now, Mutala, you are still a member of parliament. What does this mean to the NDC side, and more so how it might affect government or parliamentary business going forward? Briefly,
I thought the question would have been, what does it mean to the people of this country? I think there's a challenge to our democratic processes, and let me be very clear. Let no one be deceived into thinking that the Supreme Court or the judiciary's actions cannot be questioned. Their actions are not sacrosanct. When the citizens have challenges in appreciating the kinds of things they do, they will be in a position to criticize them. The reason why we are practicing democracy is because of the theories of checks and balances and separation of powers, as propounded by the likes of John Locke, Professor Montesquieu, and co. And it was done to ensure that power is not vested at the advantage of one arm against the other arms, to the extent that they must be in a position to check each other. Now, what we have witnessed is an attempt by the judiciary, often under this government, to disrespect and disregard the independence of the legislature. And if you read the Speaker's response to the ruling of the Supreme Court, it is very clear that he is reasserting the independence of the legislature. As a matter of fact, in a democracy, the legislature is even more important than the judiciary. You can have a military dictatorship with the other arms operating effectively. You have the executive operating, you have the judiciary operating, even in a military dictatorship. But you cannot have a democracy without parliament. And that is why when there are military takeovers, the first institution they attack is the legislature. If there is a coup, God forbid, in this country, and the legislature were to allow it to operate, then it cannot be deemed to be a coup. It means that we are still experiencing democratic governance. Now, my senior brother has indeed hammered on the knee, but I want to make one point very clear. Long before the speaker made his declaration on the floor, Afenyo had already gone to court. So my question is, I have just LLB, I'm not a lawyer, I'm not a practicing lawyer. On what basis did the Supreme Court give him the hearing, the listening ear, that the Mr. Speaker hadn't declared? He hadn't give his declaration on the matter of the 4 affected MPs. You remember he did that on Thursday. Afenyo Markin had gone to court on Tuesday, and he was seeking to serve the speaker the writ on the floor. And I was wondering whether Afenyo Markin had become a bailiff of a court, that someone has gone to court and the writ to be served to the person for whom he has gone to court is supposed to be done by the person who had gone to court. That's the first point. The other one, after the speaker gave his ruling, Afenyo Markin went to court again on the basis of what happened on Thursday. Parliamentary practice is very clear. You have been a reporter in Parliament. Now, the proceedings of every parliament is approved in the subsequent sitting. So if you have a parliamentary sitting today, for anything that happened there to be deemed official, it would have been approved through the approval of the vote and proceedings the next sitting. We sat on Thursday. The speaker gave his ruling on the matter of the 4 affected MPs. On Friday, we didn't sit. We had to sit on Tuesday. Meanwhile, Afenyo had gone to court, I guess on the same Thursday, and the Supreme, with the evidence of what happened on Thursday, evidence that was not approved by Parliament, we had to approve the proceedings of Thursdays on the next Tuesday. And in fact, whenever you are approving the votes and proceedings, you approve and adopt the speaker would have to go page after page, and that's why he
which
says,
happened on Tuesday.
And you know the
reason why I'm cutting in is that I don't want this to.
No, I'm just concluding on this. The shocking aspect is that there were two major amendments in the votes and proceedings on Tuesday. So why didn't the Supreme Court at least do the due diligence that he brought evidence that was not official? Because it becomes official after it is approved and adopted by Parliament. Yet the Supreme Court did that. And for me, that explains why Honorable says they are behaving funny.
If you have just joined us, this is Morning